Thank you very much, Gemma, and welcome to everyone to today's webinar on liquidated damages. Gemma's already mentioned the slides, so by all means do email me during or after the session and we'll get a copy of the slides over to you. So, as is normal, there's a few introductory slides about the company I work for, which is Driver Tret. So let's go through the introductions before we go through liquidated damages this morning. So we provide support to engineering and construction industries, basically across all of the areas. So whether it's building, power, infrastructure, utilities, you can see some very, very nice, pretty pictures there on the screen in front of you. We are a market leader in expert witness planning, commercial, technical, importantly, dispute avoidance, and of course, dispute resolution. Established back in 1978, we are stock market listed with over 500 staff worldwide. Our UK offices can be seen on the little map in front of you. I work between the Haslingden and the Hooton office, so between Lancashire and Cheshire, and obviously we've got other offices around the UK as well. Three main parts of the business. From the left-hand side, we have driver project services, so we can provide quantity surveyors, planners, and of course project managers on a short, medium or long-term basis to suit your particular requirements. The part of the organisation I work for is Driver Tret, and we essentially provide contract advisory services. So that could be checking your contracts, your amendments before you sign up to the contract, commercial and contract management, planning, programming and scheduling, as well, of course, as dispute resolution services. The final part of the business is Dialis on the right-hand side. Main part of that section of the business is that we provide experts into adjudication, arbitration and litigation. So that could be quantum experts, planning and delay analysts, or of course it could be technical experts as well. In addition, we can also provide adjudicators, arbitrators, and mediators. On the slide in front of you is a huge long list of the types of things we've been involved with over the past few months. So I've already mentioned reviewing contracts. Of course, drafting notices and contract correspondence is important. Checking your applications for payment and payment notices meet the requirements of the contract that you've signed up to. Looking at baseline progress programs to make sure that they reflect the impact of whether it's COVID or other events. Huge part of our business is obviously working with NEC 3 and NEC 4 contracts. So preparing and assisting in the preparation of compensation events. Similar types of work, but under other forms of contract, looking, of course, at extensions of time and loss and expense. We will provide project health checks on live contracts, making sure that your risk is covered. Assisting in negotiation, claim preparation, adjudication, looking at project restart strategy. Of course, we will do webinars exactly as we are doing for Seeker. We can do those on an in-house basis, and we do operate a help desk as well. That's the bit of advertising for our help desk. We also do have a digest magazine which is available, which does have some interesting articles in it. That's published twice a year. I think the vast majority of people who are on today's webinar will have heard me speaking before, whether on a webinar or previously in a live environment where bacon butties would have been provided. But yes, I am a quantity surveyor, chartered, expel for BT, where I worked for 5 years as a site quantity surveyor. I have gone on and done my solicitor's exams, and I've now been in construction claims consultancy for over 20 years. So what are we going to cover today? So a little bit on the background, contractual provisions, looking at some drafting issues, looking at liquidated damages post-termination and how that works, and then also looking at some recent case law as well. I am making an attempt to make these webinars just a little bit more interactive because it's very lonely here as the presenter. So my question to you, so I'm just going to make sure that everyone can use their chat. Question is, what is the largest liquidated damages figure that you have ever seen? Okay, so if anybody wants to type in whether it's an amount per day or an amount per week, just to get a feel for that. Whoa, okay, so Paul Sumner probably has it there at £4.2 million. So yeah, liquidated damage is a huge issue. Rebecca here has typed in £20,000 a week. Again, that can soon add up when you are going to be late for a period of time. I've got somebody else who's just popping at 1.6 million quid. I mean, the figures here. Okay, this one here beats me from Tony. 560,000 euros a week. My personal record is 254,000 pounds a week, and that was on Liverpool Arena. So, and it's a job quite a few years ago as well. So, definitely something that is part of the risk profile on any job. And certainly one of the things that I want everybody on this webinar to take away is an appreciation of how important liquidated damages are to look at and to factor into the overall project. So yes, I think we've definitely established that this can be a huge issue. So let's look at a background on this particular issue and also look at an introduction to this issue of damages. And we do go all the way back to 1848. And the rule there is a case called Robinson and Harmon. So where a party sustains a loss by reason of a breach of contract, that party is, so far as money can do it, to be placed in the same situation with respect to damages as if the contract had been performed. So effectively, if we're talking today generally about an employer and a main contractor, the parties have agreed the completion date for a project, contractor finishes late, the employer is looking to be put into the same position they should have been in had the contract been performed. So in other words, they would have made profit on that particular job. Hadley and Baxendale, again, another very old case. And really this was the starting point for looking at damages in two sections or two branches, as it's also called. In that particular case, the judge said, such losses as may fairly and reasonably be considered as either arising naturally, so that's rule 1, according to the usual course of things, or rule 2, such as may reasonably be supposed to be in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. Now, this particular case, not the most glamorous case you will have ever come across, it was all about the repair of a crankshaft in a mill. That particular crankshaft should have been repaired and replaced within a day, and it actually took 7 days. And the claimant here claimed loss of profit and wages. Now, unfortunately for the owner of this mill, what they didn't tell the repairing company was that the mill couldn't work if the crankshaft wasn't in place. So the whole thing stopped. The court decided in this particular case that they couldn't claim the lost profit because that wasn't foreseeable. Okay, so in other words, it wasn't in the contemplation of the parties. And that really was the starting point for people starting to think about actually writing in a level of damages into a contract. A similar case was Victoria Laundry and Newman back in 1949. Two distinct types of loss of profit here. There were the normal level of profit that this particular laundry company was going to make, and then a higher and a special level of profit because they had just won a contract from the army for cleaning uniforms. The boiler here was damaged and it was delivered 5 months later than planned. And Victoria Laundry could only claim the reasonably foreseeable loss or the normal level of profit at the time the contract was made. The foreseeable loss being a loss that a reasonable person would have concluded was liable to result. So again, had they written in a liquidated level of damages into the contract, then that would have been foreseeable. In the laundry case, the level of damages wasn't written in to the contract. Much more recent case, Balfour Beatty Construction and Scottish Power in 1994, is a case that went all the way to the House of Lords, which of course is now known as the Supreme Court. Scottish Power were providing power to Balfour Beatty's concrete batching plant, and Balfour Beatty were doing a continuous pour. Unfortunately, there was a power cut part way through, which meant that this continuous pour of concrete couldn't happen. Because the power stopped, the continuous pour stopped part way through, and what actually had to happen was they had to break out an awfully large portion of concrete, and Balfour Beatty then claimed damages for having to break out that concrete and replace it. The court decided in this case that that was not foreseeable. Balfour Beatty should have told Scottish Power that they were doing this continuous pour, which would have allowed either Scottish Power or Balfour's to put in a standby power in relation to the power actually pausing on the particular project. So again, a liquidated damages could have been added in here. So why do we use liquidated damages clauses? Well, it's for certainty for the two parties. So both parties know that if something goes wrong, what can the other side claim? It also does operate as a cap, so it does limit the contractor's liability in the event of a delay, which is the contractor's fault. Now, you might look at the level of liquidated damages and think actually it's larger than you would normally expect. If you're not happy with the level of liquidated damage, you must challenge it before the contract is signed. And we're going to look at some cases why that is so important. From the employer's perspective, it is definitely a good thing because it saves time and expense. If there's a dispute, that employer then doesn't have to put together proof of loss. The damage is already sorted out at the time the contract is made. Often, though, for the employer, what they actually want is actually the building or the structure completed on time. So the liquidated damage is effectively stands there as a deterrent to the contractor against completing late on a project. Now, if I go historically, which actually isn't that long ago, the historical position was that a liquidated damage had to be a genuine pre-estimate of loss. Okay, and the loss didn't have to be proved at the time the breach is committed. The liquidated damages clause historically was imposed automatically once the breach was established. So, in other words, once the contractor finished late. And that was definitely held in a case as recently as 1987. Historically, if the liquidated damages was a penalty, it would not have been enforceable. Now, I'm going to emphasize again, this is the historical position. This issue of penalties goes all the way back to 1914 and a case involving Dunlop Tyre and New Garage and Motor Company. And this is a very, very famous quote. The judge said, "It will be held to be a penalty if the sum stipulated for is extravagant and unconscionable in amount in comparison with the greatest loss that could conceivably be proved to have followed from the breach." So the position used to be that if it was a penalty, it wasn't enforceable, and it was a penalty if it was extravagant and unconscionable against the greatest loss that could have been proved. That's the old position. The new position was established in two cases that were held and decided back in 2015, and these were what are called conjoined cases. One of the cases involved the sale of a company, and we have Cavendish Square and L. Macdessie. So Mr. Macdessie agreed to sell a stake in a company to Cavendish Square, and the contract for the sale of the company provided that if Mr. McDessie breached certain restrictive covenants against competing, he wouldn't be entitled to, firstly, receive the last two instalments of the price for the shares, and also he could be required to sell his remaining shares to Cavendish effectively at a knockdown price. Mr. McDessie did go on and he breached these covenants. So, in other words, he set up a rival business. He argued that clause 5.1 and 5.6 were unenforceable because they were a penalty. It was held in this case that these provisions were not penalties and they were enforceable. So, in other words, under 5.1, he wasn't entitled to the last two instalments for payment for sale of the company, and also the remaining shares that he held, that Cavendish could buy them at a knockdown price. So we are no longer working on the Dunlop tyres test. We have a new test, and I've highlighted the relevant words. So, in other words, the true test is whether the impugned provision is a secondary provision, which imposes a detriment on the contract breaker, which is out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. So, if the liquidated damages figure is absolutely ridiculous, then the courts may well strike it down. But it has to be out of all proportion to any legitimate interest. Now, I wonder whether anybody on the call, on the webinar today, has actually been in this position where they have received a parking ticket. They may have stayed longer in a car park than they should have done, because that's exactly what happened to poor Mr. Beavis in this particular case. Very strange to be talking about parking tickets when really you've joined this webinar to talk about liquidated damages, but it is absolutely relevant. And this case was conjoined with the L. McDessie case. So you may have heard of this particular organisation called Parking Eye. Now, Parking Eye contracted with British Airways Pension Fund to manage a car park for Asda at the Riverside Retail Park in Chelmsford. Mr. Beavis decided on a particular day that he would go shopping, and he overstayed. The car park that he parked in allowed for 2 hours free parking. He actually overstayed by 56 minutes. So he parked, he did his shopping, he left after 2 hours, 56 minutes. And a couple of weeks later, he received a letter in the post. And the letter said, you must pay £85 because you've stayed too long. But if you pay within 14 days, we will reduce the fine to £50. Mr. Beavis decided he was not going to pay. He decided that this was an unenforceable penalty, and how on earth could a parking space be worth £50 or £85 that was a free parking space? It is unbelievable that this particular case went all the way to the Supreme Court. You can imagine the costs of the solicitors and the barristers that were involved in this particular case. But essentially, the courts were actually overrun with parking related cases, and it felt as if all of these parking cases were put in a tombola, and Mr. Beavis's case just happened to be the one that was pulled out. So the courts were really overrun with this, and somebody needed to make a decision that would apply to all of the other cases. The Supreme Court decided here that both Parking Eye and the landowner, which is British Airways Pension Fund, they had a legitimate interest in charging motorists that stayed over the 2 hours, even though that figure that they'd put in extended beyond the recovery of actual or ostensible loss. It was held that the landowner's interest was for the provision and efficient management of customer parking for retail outlets. So in other words, they wanted the churn to happen. They wanted motorists in and out quickly so that the motorists would go in, spend the money, and then leave. They didn't want people staying there for hours and hours because that would reduce the income for the shopping outlets. Parking Eye's interest was only the money that they got from people overstaying the 2 hours. They had no other income at all. And the £85 or the £50 was essentially there to meet the running costs. Again, the courts emphasised that this was a legitimate scheme, but of course it also did give them a profit margin as well. Parking Eye obviously had significant upfront costs in putting up signage and in also putting in place cameras to record people's number plates so that they could then send out the letters. And importantly, the charge was neither extravagant nor unconscionable when taking the legitimate charges into account, even though it wasn't an actual loss or a damage. Now, those two cases are not anything to do with construction, but they have been referred to in a number of construction cases since. So, the historical position was that the employer had to prove that it was a genuine pre-estimate of the likely loss. The position now is that the employer simply has to be able to show that this is not a ridiculous level of damages. Okay, so the hurdle or the barrier is actually far lower than it used to be. Certainly, when I'm reviewing contracts and subcontracts now on this point on liquidated damages, the note I will write in is that it is highly unlikely that you can challenge a level of liquidated damages post contract. So if you are going to challenge it, it has to be done before you sign the contract. So, what do contracts say about liquidated damages? Well, I am aware that an awful lot of people who are on the call today will be familiar with NEC contracts. And of course, NEC contracts actually don't mention liquidated damages at all. They have their own term, which is delay damages. Importantly, delay damages only apply if secondary option X7 is selected in contract data part 1. I've given you there the relevant clauses in the contract. I'm not going to read those all through. The important things to watch out for essentially is that the delay damages are stated per day. And of course, they will only apply from the completion date. And if you manage to get an extension of time, obviously they will run from that later date. So again, if you've got a high level of liquidated damages, keeping an eye on your entitlement to an extension of time is very, very important. X3 also does reference the fact that if there is a partial takeover, those damages are then reduced in proportion to the benefit that the employer has gained. Okay, so watch out for the fact that it's a level per day. Importantly, if X7 isn't chosen, then if the contractor fails to complete by the agreed date and doesn't, then the employer will be able to claim unliquidated damages or as much as the employer can prove. So if I'm working for a contractor or a subcontractor, my preference is to see that X7 is chosen, but that figure is as low as possible. So we do have a liquidated amount so that you know what happens in the event that you're going to be completing later than the original date. But everyone knows exactly what you can do about that. I've also quoted in the notes contract data part 1 also notes that you can also have delay damages on sections as well. And you must be very careful as to how that is filled out, which we will see in a later case. I've also put in there reference to JCT design and build. Again, I'm not going to read the whole clause out, but JCT actually makes the employer jump through several hoops before liquidated damages can be deducted. There are 3 steps under a JCT contract. There has to be a non-completion notice. Secondly, the employer has to have written to the contractor to have said that damages are going to be deducted, and also there needs to be a payment notice or pay less notice in place before the damages can be deducted. And of course, we're all aware that under NEC contracts that these are often amended, so do take care about some of the amendments that can go in. So, what drafting issues can arise? If I go back to 1987, there was a case called Temlock and Errol. And what happened in this particular case, it was a JCT 1980 contract that the parties had signed up to, and a figure of nil had been inserted in the contract as the amount of damages per week. The contractor did finish late, and the employer tried to argue that actually they could claim nil per week, which is the liquidated damages amount, or they had the choice between claiming unliquidated damages or the loss that was actually incurred. The court decided in this particular case, which is an English case, that they could only actually claim nothing in this particular case. The nil actually was an exhaustive remedy as to any damages. So if I'm working for a contractor or a subcontractor and I see nil inserted in a contract, and I actually did see that in a contract yesterday, I'm very happy with that entry from the contractor's perspective, because it means if they finish late, then actually there's nothing that the employer can claim. In other jurisdictions, it's different. In an Australian case, which is Bayes and Bracken in 1989, you needed express words to actually mean that general damages was also nilled out as well. You do need to look at the particular facts and clauses in your own contract. Now, as well as nil in a contract against liquidated damages, you might also see not applicable. Now, again, this is an Australian case, and in this particular one, liquidated damages was inserted as NA. The particular arbitrator here held liquidated damages didn't apply, but unliquidated damages did apply. I think that that's exactly what would happen in the UK. So my view is if I see NA and I'm working for the contractor, that I actually want that replaced with nil instead, because I do want to actually be sure as to what the parties will incur in the event that a project finishes late. Now, there is nothing to stop a party actually capping the LDs as well. So that could be expressed as a percentage of the contract sum. I've given you an example clause there where the liquidated damages is capped at 20% of the contract sum. Now, for me, that's a high figure, and you might want to consider a lower cap of 10% of the contract sum or even 5% or lower. Is it the original contract sum or is it the finally adjusted contract sum? Again, clarity is required. Generally, if I'm on for the contractor or the subcontractor, my preference is to see that as the contract sum, which is stated in the contract, not the finally adjusted one with CEs or variations added in. If there is an ambiguity in drafting, of course, the Latin principle of contra proferentum will apply. So in other words, whoever has drafted the clause, the ambiguity is construed against them. So in this particular case, if it was the contractor that had drafted that clause, then If the finally adjusted contract sum was higher, the courts would say it's the higher figure that would apply the 20% to. Another issue that can come up with liquidated damages is sectional completion. In the case of Gleeson and Taylor Woodrow, again, it was another JCT contract, and the sectional completion provisions were actually put in the preliminaries rather than being in the contract itself. And the court decided here that the fact that they were hidden in the prelims or the bill of quantities, that wasn't good enough. And therefore, the sectional completion damages did not apply. And that was because there's a clause in JCT that says nothing in the bills can override the conditions. Quite simply, it was an error in contract drafting. And the contractor in this particular case effectively won the case. They didn't have these sectional damages imposed. A very recent case, only 2019, so last year, involved the University of Warwick and Balfour Beatty. Again, yet another JCT contract. This involved the National Automotive Innovation Centre in the Midlands. And the contract itself was split up into 4 sections, and there were liquidated damages for each of the sections in this particular case. There was a very long definition of practical completion, and it included a statement that practical completion of any of the sections was deemed not to have occurred if the employer couldn't occupy the particular section. Unfortunately, not enough attention was looked at before the contract was entered into. And it was only after the contract was signed and when actually the project was a significant way along that Balfour Beatty realised that the liquidated damages were in effect inoperable because completion of any of the sections couldn't take place on its own. So in very simple terms, electrical wiring ran through all 4 of the sections, and until the electrical works were actually completed and commissioned, none of the sections were completed at all. So Balfour Beatty quite simply said the liquidated damages provisions were inoperable, and so therefore you couldn't claim liquidated damages on any particular section. So no liquidated damages on the sections could be imposed at all. You could only have liquidated damages on the end date. This went to adjudication, and the adjudicator agreed that the liquidated damages provisions on the sections were inoperable and effectively crossed them out. And obviously Balfour Beatty were very happy with that. The University of Warwick were not happy at all, and they took this issue to court. And they wanted a decision that Balfour's had signed up to this contract. The liquidated damages did apply for each of the individual sections. And quite frankly, it wasn't Warwick's fault that Balfour Beatty had signed something that was effectively impossible. They wanted the damages on each of the different sections running until each of the separate sections was completed. The judge overturned the adjudicator's decision and effectively said that the damages were operable. So if we had part 1 going from week 80, part 2 going from 84, part 3 going from 88, and part 4 going from week 90, the fact that Balfour Beatty couldn't actually finish the whole job until week 90, the damages could be applied from each of the earlier dates. The judge described this as a business common sense decision. Now, I have to say that I can argue this particular case both ways. The judge said the parties had agreed to sectional completion provisions, and if they were struck out, quite simply, all of those provisions were a waste of time. And the parties had agreed them, and therefore they should be imposed. Effectively, what they were looking for was contract certainty. So again, for anybody who's on this webinar, what I would definitely advise is at tender stage that you do spend time looking at the different sections and making sure that you can actually finish the individual sections separately from all of the other sections. If you can't, challenge it at the time. So, on what grounds can you challenge liquidated damages? You could certainly try and argue that the breach that's happened isn't within the scope of the liquidated damages clause. That is difficult. Secondly, that the clause is invalid or void for uncertainty. If you're using a standard form contract such as NEC or JCT, that is also going to be difficult. The third one, non-compliance with a condition precedent. Now, that would certainly be something that I would look at under a JCT contract, but there isn't any condition precedent under an NEC contract. A fourth option is that the contract machinery is broken down. So, in other words, that the parties haven't operated the relevant clauses. Again, that is very difficult to argue. And it's only in a very, very small number of cases that that's been successfully argued. The final option is that the clause is a penalty. Now, remember, historically, that was obviously an option, but because of the Parking Eye case and the El McDessie case, this is now very, very difficult to argue. You would have to show that the amount that is stated in the contract is out of all proportion to the other party's legitimate interest. Something that has attracted recent attention from the courts more recently is how do liquidated damages work post-termination. So again, I've got a bit of audience participation for you. The question I want to ask you here is, if the contract is terminated, can the employer carry on claiming liquidated damages after termination? So if you can type yes, if you believe that the liquidated damages continue to tot up, and no for the liquidated damages stop. Okay, so yes, liquidated damages do carry on after termination, and no for they effectively freeze and no further liquidated damages can be claimed. So I have I think I have 3 no's so far there. Let's see if anybody else has got any thoughts. So yes, if they continue after termination, and no, if they don't. I think the vast majority of people are saying that they don't continue after termination. Well, we are in a very, what I'm going to describe as a very foggy situation at the moment. If I go back to 2010, we've got somebody very, very sensibly saying it depends on the contract. I like that answer. Depends on the terms of the contract is also a valid option here. So, first case to have a look at, Hall and van der Heijden, 2010. It was held here that liquidated damages provisions did survive termination. So in other words, yes, the liquidated damages provisions continued to roll if the contract is validly terminated for the contractor's default. The judge held, interpreting the contract in the way asserted by the contractor, and effectively said it would not be a common sense interpretation of this or of any construction contract. So in other words, if liquidated damages did not survive, then a defaulting contractor could decide to abandon the works, bring the contract to an end, and that would mean that the contractor's exposure to liquidated damages effectively froze, and then the contractor would benefit from his own breach. So that was the position in a case in 2010. And we also had another case in 2010, which is Shaw and MFP Foundations. Now, in this particular case, the contract provided for liquidated damages of nil per week. Due to poor performance, the claimant terminated the contractor's employment. The arbitrator held that nil was the only right to claim liquidated damages even after termination. The court in this particular case said, after the date of termination, the parties are no longer required to perform their primary obligations under the contract, and the contractor's obligation to complete by the completion date no longer remains, and the provision for liquidated damages becomes irrelevant. In its place arises an obligation to pay damages for the employer's losses resulting from the breach of contract, including damages for any loss resulting from any further delay. So, what the judge in this particular case is effectively saying, it was a swap. So, it moved from nil to unliquidated damages. So, they're two different 2010 cases. We then move on to a case in 2019. What we have here are 5 EPC contracts for solar power generation plants. Unusually here, the contractor Prosolia was insolvent, and the client here was suing the parent company of the contractor, who was a guarantor under 4 of the EPC contracts. And there were 3 questions that were asked. Number 1, were the liquidated damages enforceable, or were they a penalty? Was the contractor liable for liquidated damages after termination? And thirdly, was whether force majeure was applicable at all. So looking at the first point about the enforceability of liquidated damages, well, the contract did confirm that the liquidated damages was a penalty of £500 per unit per day. So it was actually described as a penalty. There were no negotiations at contract stage on the liquidated damages figure, and the liquidated damages amount across all 5 contracts was the same, even though each plant had a different output. The loss would be affected by output and the electricity price, which was prevailing at that particular time. And of course, the initial output would fluctuate depending on how the works had been done. The court did look at this issue of genuine pre-estimate of loss, which of course is the historical position. The court had no difficulty whatsoever in the figure being the round £500 per unit per day. And they then referred to our parking case, so the parking Iron Beavis 2015 case, and the court held that the liquidated damages were enforceable. So you can see here clearly that they've moved to this new test, even in construction. The second question, was the contractor liable for liquidated damages after termination? Well, they argued that the contractor cannot possibly influence the progress of the project after they aren't involved. And therefore, the contractor would be liable for essentially excessive liquidated damages. They did look at the whole case in 2010, and it was decided that liquidated damages do continue after termination, and in this particular case, up to the date of commissioning of the plant. And in particular, they decided here that otherwise the employer would be punished for its correct decision to terminate. So this is the case I would look at if I'm giving advice at the moment. In other words, the contractor is liable for liquidated damages after termination. But I am going to remind you of Ben's comment. Of course, if you had a clause in the contract that said that the contractor wouldn't be liable for liquidated damages in the event of termination, I think that that would stand. Probably for me, the most annoying part of this case is the third question that was asked, and that was on force majeure. What had happened here during the course of the contract is that there were protests against this solar panel farm being constructed. And what the parent company argued here was that, look, you can't claim damages when there was a force majeure issue that prevented the work being carried out. And the court said here, well, yes, we agree with you, but there was a very clear notification clause in the contract that said, if you want an extension of time because of force majeure, you have to give the relevant notices. And of course, here, the contractor Prosolia hadn't given the correct notices and therefore wasn't entitled to an extension of time. So, in other words, if the notices had have been issued, then the parent company wouldn't have had to have paid the liquidated damages, which is a real annoyance for them. So, for the sake of a few letters, they could have had these liquidated damages significantly reduced. Another 2019 case, Triple Point Technology and PTT Public. This was all about a supply contract for a software system. And again, the question was asked, did liquidated damages for delay apply post-contract? Helpfully, the judge said there are three possible answers here. The clause doesn't apply, it applies up to the termination of the first contract, or it applies up to completion of the work by the second contractor. Here, the contract specified that liquidated damages were to be calculated until the date that the employer accepted the work. The Court of Appeal, so a high level of court here, interpreted this as the date when the employer accepted the completed work from the original contractor. Now, possibly a little bit of poetic license has gone in here. As the original contractor didn't complete the work, the Court of Appeal concluded that the liquidated damages clause could not apply. It would appear that we are waiting a Supreme Court judgment in this particular case. So probably I should have added 3 dots. So we are still in a little bit of a state of flux. The 2019 Triple Point case is a court of higher authority. However, again, going back to Ben's point, it will turn on its own facts as well. Now, the last thing I want to cover in today's webinar would be subcontract liquidated damages. If I just ignore the NEC contract for a few minutes, normally the situation is that it is unusual for standard forms of subcontract to provide liquidated damages as a remedy for non-completion. And that's normally because, again, if we look at this historically, the calculation of a genuine pre-estimate of loss is difficult. Now, even if we move that historical position aside, deciding what level of damages to put into a subcontract is difficult. And so normally provisions are included in a contract that I would talk about. I'd give the analogy of a rolling snowball. So the employer rolls down a liquidated damages amount to a contractor, and the contractor then rolls down the hill to the subcontractor an unliquidated level of damages, but the subcontractor is aware of what the main contract damages are. Now, this can cause problems to main contractors because when you are on unliquidated damages, the contractor has to prove that the loss was actually incurred as a result of the subcontractor's breach. And when you're working on a job where you've got 10, 20, 30, 40 subcontractors, can you honestly say it was the fault of subcontractor X over all of the other subcontractors that they were the reason for the delay on the particular job? And of course, the main contractor also has a duty to mitigate as well. Well, a solution is to include a level of subcontract liquidated damages here. And that's what NEC3 and NEC4 subcontracts do, where you do undertake a calculation of loss for each subcontract package. And of course, this is far easier since the parking eye case. Now, again, I'm going to ask the audience at this point, bearing in mind that I appreciate that we do have main contractors and subcontractors on this webinar, do you generally use or do you generally accept subcontract liquidated damages yourselves? Have you got any contracts at the moment where you've actually written in subcontract liquidated damages, or you've accepted subcontract damages? So can I have a yes for yes, we do have subcontract liquidated damages, or a no for no, we don't have subcontract damages? We've got a few yeses being typed, and yes, both ways. So I would say most people are saying yes, but we do have a couple of no's. Again, whether you're a main contractor or subcontractor on the webinar, I would want you to be very clear as to whether it's unliquidated damages or it's liquidated or subcontract damages that have gone in. If you are writing in subcontract liquidated damages, if you're accepting them, 3 types of loss. You've got this main contractor's own cost of delays. You've got the main contractor's liability for liquidated damages or delayed damages up the line. And then you've got the claims that arise from other subcontractors and suppliers as well. It is difficult to put this calculation together. There is an element of guesswork. I think the only point that I'm going to make here is that it is easier since the Parking Eye case to actually have higher levels. So if I'm talking to subcontractors, this issue of having a cap in the contract is more important. On the next slide, I've just confirmed here that this is how you would fill in the NEC3 subcontract, quite simply putting in a level of delay damages for completion of the whole of the subcontract works. And again, it's a figure per day that's inserted. A little bit more there on the last slide about passing down main contract damages. Again, it's very difficult to do that because you have to make sure that you can prove that that subcontractor was the critical cause of delay on the project. Okay, at 11:56, that pretty much concludes. There's another case there, but I will let you read that in your own time. That pretty much concludes what I wanted to say about liquidated damages today. Can I ask, has anybody got any questions that they want to ask at this point? I'm just going to have a flick down things that were inserted. I don't think that I saw any questions, but I am going to just check with Gemma. Gemma, have you seen any questions that I should be answering?
No, we haven't had any pop up.
The beads of sweat disappear from my brow at this point, and I cannot see anybody typing, which is very, very welcome. Obviously, if I just go on to my final slide here, you do have my contact details. I would be delighted if anybody did want to contact me with a liquidated damages question. By all means, do that. I will be on the line for a couple more minutes, just watching out for anybody else who wants to type anything. You can see, obviously, my email address there if you want a copy of the notes. By all means, do get in touch. Obviously, we are about to hit the summer season in terms of webinars, but I have been in contact with Gemma and Guy already for the autumn season. Many exciting topics on their way, which I'm sure that everybody is very excited about, she says nervously. That's all from me. So anything else from you, Gemma?
No, just a thank you again to Geraldine for another fantastic webinar, and hopefully everyone's found that useful. We're getting some thank